The Supreme Court is now being asked to weigh in on a major case that could have national implications for concealed carry rights. The case is Woolford v. Lopez, a direct challenge to Hawaii's restrictive concealed carry laws. This case could ultimately determine whether states like New York, California, and Hawaii can continue to enforce sweeping bans on carrying firearms in public. What makes this case even more significant is the growing momentum behind it. Not only are the plaintiffs pushing for emergency intervention by the Supreme Court, but the Department of Justice under Attorney General Bondi, along with 25 states and multiple Second Amendment organizations, have all filed briefs in support of the challenge. They're urging the court to step in and put an end to the unconstitutional restrictions being enforced by anti-gun states. At the heart of the case is a new law passed in Hawaii in response to the Supreme Court's Bruen decision, which clarified that the Second Amendment protects the right to carry firearms in public for self-defense. Instead of complying with that ruling, Hawaii doubled down. The state enacted a law that effectively banned carrying on nearly all private property that is open to the public, unless the property owner gives explicit permission, usually through posted signage. This law didn't go unchallenged. A district court initially issued a temporary restraining order against the law, which was later converted into a preliminary injunction, blocking the private property restriction. The court concluded that Hawaii's law was likely unconstitutional under Bruen. However, the case was appealed, and the Ninth Circuit Court of Appeals reversed that injunction. The Ninth Circuit claimed that Hawaii's law was justified by historical restrictions on things like hunting on private land, an argument many see as a stretch and as inconsistent with what the Supreme Court actually said in Bruen. After the Ninth Circuit's decision, the plaintiffs tried to have the case reviewed en banc, meaning by a larger panel of judges, but that request was denied. Now the case is headed to the Supreme Court with a formal request for emergency intervention. Now let's be honest. This case faces an uphill battle. Historically, the Supreme Court has rejected almost every interlocutory petition, meaning cases that reach the court before the final decision at the trial level. That includes cases involving temporary restraining orders, TROs, or preliminary injunctions, like this one. However, this challenge is different. There's significant weight behind it. The United States government, under the Trump administration, has filed a formal brief supporting Supreme Court review. In their amicus brief, the DOJ argues that Hawaii's near-total ban on concealed carry directly contradicts the court's ruling in Bruen and the constitutional history that supports the right to carry firearms in public for self-defense. What makes this unique is that the Trump DOJ is urging the court to hear this case early, despite it being at the preliminary injunction stage. They argue that nothing further can be resolved by the lower courts. In fact, the state of Hawaii itself has already admitted, in front of the Ninth Circuit, that there is nothing more for the lower courts to determine. That, according to the DOJ, makes this case ripe for Supreme Court review right now. This is critical because it reveals a major contradiction in Hawaii's arguments. In the Ninth Circuit, Hawaii's legal team explicitly stated that there was no need for additional evidence or trial proceedings. But now, in front of the Supreme Court, Hawaii is trying to claim that the case is still too early for review and the record is not fully developed. That's a direct contradiction. Hawaii also argues that since there is no circuit split, meaning other appellate courts haven't yet ruled differently on this specific issue, the Supreme Court should hold off and let lower courts handle it. They claim that review is premature and that the court should ignore what the DOJ said, even going so far as to refer to the federal government's support as being from an uninvited guest. But again, this directly clashes with Hawaii's earlier statements. In the Ninth Circuit oral arguments, Judge Schroeder asked Hawaii's attorney, "What else is there left to be decided in this case?" The attorney responded, "We think that there isn't anything left, and at the end of the day, this does not violate the Second Amendment." That's a firm concession. This contradiction was highlighted by Mr. Woolford's legal team in their latest brief. They emphasized that Hawaii can't have it both ways, telling the Ninth Circuit there's nothing more to litigate, than telling the Supreme Court the case isn't ready. Even Judge Van Dyke, in his dissent when the Ninth Circuit refused to rehear the case en banc, called out this tactic. He said Hawaii's law effectively nullifies the right to carry. Under Hawaii's law, You might be allowed to carry on a few streets and sidewalks, but the vast majority of public spaces would be off limits. That's not regulation, that's eradication of the right to bear arms. In addition, Hawaii is now arguing that its own state history should take precedence over national historical tradition when interpreting the Second Amendment. That's a key point of disagreement. The plaintiffs make it clear. The Supreme Court's analysis in Bruen is based on national history at the time of the founding, not selective interpretations of a single state's history. Arguing otherwise, they say, is not only misleading, but legally flawed. So, with the Trump administration stepping in, it seems the state of Hawaii may have unintentionally put themselves in a difficult position. Much of Hawaii's brief is focused on urging the Supreme Court not to take the case right now, arguing that the trial court still needs time to develop the record and gather more evidence. They want the court to hold off, essentially to kick the case down the road. But here's the problem. That's not what Hawaii said in the Ninth Circuit. Back then, their legal team argued that no further development was necessary. They claimed the case was already fully ripe for a decision. This contradiction has now become central to the current dispute, and it raises serious questions about Hawaii's position. The big question now is, what will the Supreme Court do? Will they follow Hawaii's request to delay review and let the lower courts continue the process? Or will they take into account what the United States government has argued, along with the plaintiffs, and recognize that this issue is fully developed and demands immediate review, even at the preliminary injunction stage? From a legal standpoint, both the plaintiffs and the federal government agree that the facts have been fully laid out, and nothing more needs to be addressed at the trial level. And again, that's exactly what Hawaii previously told the Ninth Circuit. It's a contradiction that's hard to ignore. This case is one to watch closely in the upcoming term. It's expected to be sent to conference, and it may be relisted multiple times, a signal that the court is taking it seriously. Ultimately, the Supreme Court will decide whether to address this major constitutional question now or delay it for later. That's the current situation surrounding the major challenge to Hawaii's concealed carry ban. It's a case seeking emergency review from the Supreme Court, and it could have nationwide implications for how Second Amendment rights are interpreted after Bruen. As soon as there are new developments, I'll keep you updated right here. Thanks for watching. Be sure to like, leave a comment, and subscribe so you don't miss any important updates.